subsequently by the appellate court. We, the homeowners, David and Marvin Patterson, initially and finally prevailed at the trial court level as the matter was dismissed following the hearing on 4/7/12 due to lack of standing by Civic Mortgage per the legal ruling of Wells Fargo versus Jordan, and I'll get into that in a minute. What I also need you to understand is we were fighting this for 6 years, 4 of which we fought without an attorney. The case was then appealed to the 8th District by City Mortgage, who suggested that the Jordan decision be revisited and that the 8th District wait for the highly anticipated at the time Federal Home Loan versus Schwartzwald decision before ruling in this case. Now, the Jordan ruling, for the sake of clarity and so that you understand, this was the watershed decision with respect to foreclosure protocol in the state of Ohio as of 2009. The decision, in essence, made it mandatory that a bank or other financial institution, as plaintiff in a foreclosure action, possess both the note and the mortgage at the inception of filing. Okay? Everybody understand where I'm going with this? Okay. Subsequently, the Federal Home Loan versus Schwartzwald decision, which was rendered by the Ohio Supreme Court in 2012, it hadn't been rendered when they heard our case, but was in fact decided by the time our ruling was journalized and released on December 13th, 2012. This is where it gets interesting. The case was curiously utilized to overturn the trial court's decision, which means they reversed our dismissal. And even though no other Ohio court of law appeared to draw this surrealistic conclusion from Schwartzwald that the 8th District did, they in fact came to the conclusion that Schwartzwald, when it mentioned that Federal Home Loan neither owned the mortgage or the note, came to this surrealistic conclusion that if they owned either, that would have been sufficient for standing. We know that's not true, but that's what they did to overturn our decision. On top of that, after they used this to do something that isn't done in any other county, now mind you, when this was rendered, the Ohio 8th District rendered this decision. There are 88 counties in the state of Ohio. 88 counties. This was the only county where this decision was relevant. They couldn't do this in any other county. But now understand another dynamic. Cuyahoga County has more African Americans than any other county in the state of Ohio.
We figured that.
So if we have the most African Americans, it only stands to reason we have the most African American homeowners. What better way to do the gentrification thing than with the courts? So now we're in a situation where it was overturned by the 8th District. The Supreme Court of the state of Ohio stood back and said, we're not going to touch it. When we appealed it to them, they said, we're not even dealing with the jurisdiction on it. So now, on October 29th, they say they're coming to put us out. And we're telling them, in no uncertain terms, if you want the OK Corral, you can get the OK Corral. Because we're not leaving. It's just that simple. Now, we don't want this thing to get violent. Nobody wants that. But this is what I've said over and over and over again, and people that know me know I stand by this rule. Without the heart of a martyr, you don't win. You don't have to die for the cause, but you better be prepared to lay it on the line if it comes down to it, because that's the only thing they respect. Thank you so much. I appreciate it.